Be seated. Our final case on the calendar this morning is Tokyo Marine Management versus P-Zone.
May it please the Court, my name is Bill Rogner, and I represent the employer carrier in this workers' compensation appeal. I'd like to reserve 3 minutes of my time for rebuttal. Your Honors, this case involves two orders. One entered in 2002, one entered in 2005. And this case involves an employee who injured his wrist. That injury was superimposed over pre-existing arthritis. The judge below ruled that the findings in the 2002 order precluded the employer carrier from raising certain defenses, including major contributing cause in 2005. Moreover, despite evidence that the claimant had become disabled for non-compensable problems with his back, neck, shoulder, and knees, the judge ruled as a matter of law that apportionment was not proper. Your Honors, we assert that the primary error below was in the judge's improper application of the doctrine of res judicata. We assert that it was inapplicable for a couple of reasons. First, there was no...
Are you abandoning the claim about the expert witness?
No, sir. I'm absolutely not.
Prioritize.
I'm trying to prioritize with my limited time. And if you'd like me to turn my attention to that issue, I will.
You go right ahead. If you think that's your best argument, I'd rather you start with.
Thank you, Judge. Again, there are two reasons that res judicata didn't apply. First, there was no identity of issues between the first and second order. The first issue addressed one issue and one issue only, authorization of a surgical procedure, a procedure the claimant ultimately declined. The second hearing involved completely separate issues. Didn't have anything to do with surgery. The issues were temporary total, temporary partial, permanent total disability benefits, and compensability of a new condition, carpal tunnel syndrome. But more importantly, the second reason that res judicata should not apply is that the JCC erroneously ruled that the 2002 order awarding surgery forever precluded the employer carrier from challenging major contributing cause at any point in the future. To be fair to the judge did not have the benefit of 4 cases issued by this court this year following the issuance of the judge's order in this case. The first was the Checkers case, which was written by you, Judge Davis. The second was Carlucci. The third was Trimble. And the fourth, which is not in the briefs, more recently the Mims case, Mims versus Consolidated Staffing. All of these cases were issued between April and October of this year. Each of them rejected the theory that major contributing cause is a once-and-for-all determination. Each of these cases rejected prior erroneous conclusions reached by this court in Collins, Hutchinson, and Bussey, and receded from those cases. Those cases confused the concept of compensability of the injury and major contributing cause. Your Honors, this case is controlled by section...
Weren't those cases dealing with the 120-day rule?
Absolutely they were, Judge.
And what evidence did you have subsequently that stated that there was different medical or things out there that changed this condition that put you under those exceptions?
Well, let's look at it, because the doctor at the time of the 2002 hearing was Dr. White. If you read their brief and you read the order of the judge, he only talks about Dr. White's deposition testimony in 2002. That's all he talks about. That's all the claimant talks about. But Dr. White was also the doctor at the 2005 hearing, and Dr. White's records were admitted into evidence, and his opinions are contained in those records. Dr. White saw the claimant 6 times after the first hearing. And Dr. White's opinion did change. For example, in July 14, 2004, Dr. White opined that at that point there were no longer any work restrictions related to the compensable injury. More importantly, the last visit, February 2005, Dr. White opined that at that point there was no longer any causal relationship between the claimant's wrist problems and my accident. In fact, he said, the current problem is not related to his workers' compensation injury, and I've advised the patient of that fact. That's the medical evidence that changed after the 2002 hearing. Now, there's no question. We can't challenge the claimant's right to benefits in 2002, and we're not trying to. We never did. What we're challenging is the claimant's entitlement to a completely separate set of benefits at issue in 2005. And what this court focused on is the statute, in all of these other cases I cite, is the statute I'm asking you to focus on today, 440 44091B. That's the statute that says this, Judge. It says that an employer carrier is responsible for the provision of benefits only so long as the original work-related injury is and remains the major contributing cause of the claimant's need for treatment and entitlement to benefits. Now, what we're asserting and what we asserted below and the judge would not consider was that the claimant's problems in 2005 were not related to the original injury that occurred back in 1999. And the judge did not consider this evidence from Dr. White, did not consider these opinions from Dr. White, because the judge said, that's it. I made a determination in 2002 that the need for treatment then was, or the major contributing cause and the need for treatment then was the work-related injury. And as far as I'm concerned, that's it forever. This court very carefully broke down 44091B in Checkers and Carlucci and Trimble and Mims and said, look, major contributing cause is subject to repeated challenges because conditions wax and wane. In our case, we have an aggravation of a pre-existing condition. That aggravation could have been temporary. It could have been permanent. There's all kinds of degrees as to the extent of the exacerbation. And in this case, Dr. White ultimately opined that it went back to baseline. The judge wouldn't let us address that. On the apportionment issue, we assert the judge erred as a matter of law for two reasons. Number one, he found that apportionment only applied to the compensable condition, the right wrist, and that a consideration of all the other disabling conditions was not appropriate. He called them immaterial in the order at page 892. The second reason is he again said that the concept of res judicata prevented us from arguing apportionment. Now, keep this in mind. Apportionment only applies to permanent total disability benefits. Okay? The statute says, at least the statute in effect at this state of accident, said that apportionment did not apply to medical benefits and it did not apply to temporary indemnity benefits. The only benefit at issue in 2002 was surgery. Permanent total disability benefits weren't at issue in 2002. They were at issue in 2005. The only time we could have raised apportionment is at the time of the 2005 hearing. Yet the judge says you cannot do that based on res judicata. Your Honors, the facts are uncontroverted. This gentleman worked for 5 years in his regular occupation following his work-related injury. He was ultimately laid off from a subsequent employer for reasons unrelated to his injury in 2004. He only stopped working permanently and received Social Security disability benefits after he became disabled from his neck, his back, his shoulder, and his knees. Under the cases cited in the brief, apportionment is proper in two scenarios that are present here. One, where a pre-existing condition not disabling at the time of the accident becomes disabling later. That's this gentleman's back and his neck. And the second situation is when a injured worker suffers a subsequent injury or condition that renders him disabled. In this case, that was his shoulder and his knees. The judge refused to consider evidence with regard to apportionment. We're asking you to remand the case and direct him to do so. And Judge Browning, that takes me to the issue you brought up, which is the use of Attorney Lopez, who testified as an expert in support of the permanent total disability claim. I will concede that Attorney Lopez is an expert in Social Security law. That's not an issue. It is our assertion that it was the subject matter of the testimony that was improper. He did two things. One, he came in and he explained federal Social Security law to the judge. And number two, he opined that the plaintiff should win the case, that the claimant should win the case. I submit that this practice, relatively common in workers' compensation cases, is unparalleled elsewhere in the law. I ask you to consider a hypothetical. Take a standard tort case, and the plaintiff is represented by Attorney Smith. Attorney Smith wants to bring in Attorney Doe, another tort lawyer, to testify to the judge and jury. And he wants Attorney Doe to testify to the judge and jury about the elements of a tort claim, and then to provide an opinion that the plaintiff's case is meritorious and that the jury should award or should rule in favor of the plaintiff. Would that be proper? I submit that it would not be proper. And that's exactly what happened in this case.
And your tort claim, if you had an attorney that was had engineering background, it might be.
Well, he wouldn't be testifying about the elements of a tort claim, because the cases I cite in the briefs, Kefitz, Lee County versus Barnett, Siebert, Devon, all of these cases say this, that you can't use expert testimony to explain the law to the judge. The judge is charged with understanding the law. And the only people that are supposed to help the judge understand the law are the plaintiff's lawyer and the defense lawyer, and I guess the clerks.
Well, there's the evidence rule. I can't think of the rule number right offhand, but it says that it is not objectionable for an expert to advise a jury or the fact finder on the ultimate issue.
And Judge, they pointed that out in their brief, and I admit that those cases exist, but that's not what I'm talking about. It's not the ultimate issue. Is the claimant disabled? That's the problem. The problem is that we're using a lawyer to come in and explain the law to the judge. Judge, here's the law, and here's how the law works. And then the lawyer explains to the trier of fact that this is how the law is to be applied to these facts. And that, according to all the cases that we rely on in our brief, is an improper use of an expert. That the judge and the lawyers who are presenting the case are the ones that are charged with presenting the law, and the judge is supposed to understand and interpret the law. You're not supposed to bring in an expert to explain to you the elements of a tort claim or the elements of a med-mal claim or that very complicated class action case we heard before ours. That is not proper use of expert testimony, and it happens all the time in comp cases because you have never said you can't do it. And
so
some of the judges.
You're asking us to say it for the first time? Is that your position?
I'm absolutely hoping you'll say it for the first time.
Right.
Some of the comp judges won't allow it. Some of them say, no, I'm not allowing that. I try cases in front of all of them.
But in the acid test, whether or not the particular JCC thinks that the testimony will help him or her.
Well, that is one of the 4 factors that we're told to analyze in all these cases. But keep in mind that we're also told to look at whether or not the risk of undue prejudice outweighs any probative effect. And I would assert that it does.
I look at those 5 steps, Counselor, and it almost seems that, that the expert, if you're limiting where you say he should be limited, all he can do is get up and read the law to him. Because all of it says is you look whether the medical severity of the impairment meets or equals the listings in Appendix 1, or whether the claimant can still do his past relevant work. I mean, that just begs for some kind of opinion on the facts.
It does.
Circumstances.
It does, Judge. I've run out of time, but I'll tell you who it begs it from. The vocational experts who are allowed to testify in Social Security hearings and who have expertise about whether someone can work. That's who provides that testimony and who actually provided it in this case.
Counsel, just one question. In
Yes,
reference
Judge.
to your apportionment argument,
Yes, sir.
is there any evidence in the record as to the percentage of disability that was attributable to the pre-existing condition?
The evidence with regard to apportionment comes from the testimony of the vocational expert Jerry Panaccio, who broke down the percentages of jobs in the national economy that each of these impairments removed or made inappropriate for the claimant. It's not a doctor that provided that testimony. It's a vocational expert that provided the appropriate testimony. Thank you.
May it please the Court. My name is Bill McCabe. I represent the claimant, Richard Pizon. On the testimony of David Lopez, the employer carrier in the brief challenged it on 2 grounds. One, that Mr. Lopez was an advocate and not an expert, and secondly, that he expressed a legal conclusion inappropriate for an expert witness. The first basis, that he was an advocate, I submit is not properly preserved for appellate review because that wasn't the basis of the challenge below. The second ground, they did challenge below, but as you pointed out, Florida Statute 90.703, or excuse me, I think it's 92.703. Nope, I was right the first time. 90.703 specifically provides that an expert's opinion is not objectionable simply because it renders an opinion on the ultimate issue. Mr. Lopez has been an attorney representing Social Security claimants. He's tried 3,000 cases. He's been an expert in workers' compensation settings 600 times. The employer carrier's firm has used him as an expert The judge did not abuse his discretion in allowing Mr. Lopez to testify, and furthermore, even if he did, it's harmless error, because there was also testimony from a vocational counselor, in fact, two of them, one, Dr. Pinder, who opined that the claimant would qualify for Social Security disability based solely on his wrist injury, and then, of course, the employer carrier had one who said otherwise, but the judge accepted Dr. Pinder, who's the vocational counselor. So it would be harmless error anyway. Now, as to the second issue, the judge, we submit, properly found that he'd already determined in his 2002 order that the industrial accident is the major contributing cause of the claimant's need for right wrist treatment and fusion surgery as recommended by Dr. White, and it is therefore too late for the employer carrier to again argue that the claimant's current wrist condition and need for fusion surgery is not related to the industrial accident based on res judicata. And workers' comp cases, like any other, are bound by the doctrine of res judicata.
But Mr. McCabe, what he's saying is that the major contributing cause is and remains the basis for the benefits claimed. And I'm paraphrasing that. What do you say in response to that?
Well, in response to that, I say that the condition that the judge found that the accident was a major contributing cause is the same condition that currently exists. Now, for example, they talk about Dr. White saying that the arthritic problem is not related to the workers' comp accident. He did say that in his February 23, 2005 report. But he also said in his May 7, 2001 report, which was prior to the judge's 2002 order, and this is on page 720 is one place where it is, it says, clearly his carpal tunnel is work-related. His degenerative arthritis is probably not related to his work. So
what's the date on that opinion?
that was in the report of Dr. White dated May 7, 2001, on page 720 of the record, which is prior to the 2002 order. Now, the judge found in the 2002 order, primarily based on Closet Maid versus Sykes, that the accident was nevertheless the major contributing cause of the wrist condition and need for the surgery because the claimant was primarily asymptomatic before the accident and became symptomatic after the accident and so on and so forth. So,
well, I'll give you that, Mr. McCabe, that obviously there was CSE to support that earlier ruling. But what I think opposing counsel is saying, they should have been given a chance to produce or introduce CSE to show that the need for treatment was no longer based upon the major contributing cause of the accident under Checkers. And I would like for you to respond in that vein, if you will.
well, the cases that he relies on, Checkers, et cetera, you know, as you pointed out, they are the 440-24 waiver statute. But the question is can you retry whether the condition is compensable or not? I mean, even in these cases, like in City of Ocoee v. Trimble, the court noted that there's a distinction exists between the concept of compensability and a worker's entitlement to either compensation or benefits. Compensability of the wrist condition has already been determined. The judge found the entire wrist condition was compensable and required surgery. Now, the claimant elected not to have it, but the wrist condition is the same now as it was then. The judge found it to be compensable. They can't keep trying the compensability of the condition.
But aren't they coming back now saying that that condition entitled the claimant to benefits? But they're saying now, or they thought they had the right, which the judge cut off, to say that that condition no longer is a reason for the need for benefits. They're saying that some other cause that has nothing to do with the industrial accident. You know, if someone had a compensability determined of a wrist and then later had a benefit for a toe, they wouldn't be entitled to benefit of the tow because of the risk with it. So how about helping me in that area a little bit?
Well, I mean, I agree. I mean, if it's a tow or if it's something different, that's a new issue. But the judge has already ruled that this claimant's wrist is a compensable condition. The judge already ruled that.
But what it seemed like the judge, by saying it's res judicata, was keeping him from coming in and saying, we want to prove a tow rather than a wrist. Am I wrong there?
Well, I mean, if that is in fact the case, then the doctrine of res judicata as it relates to a compensable condition is just thrown out the window. I mean, we could retry compensability every time the claimant raises a new benefit.
Well, isn't that exactly what Checkers says? That you can't, if something comes up later and you say, and they come in and prove medical conditions, say it's now, this is all pre-existing, got nothing to do with the accident, major contributing cause of the accident. Can't they do that? Can't they present evidence under Checkers to do that?
Well, Checkers, the judge found, and also Carlucci, which is another case they cited, another 120-day case, the judge found in both of those cases that the claimant had reached maximum medical improvement from the compensable condition with a 0% permanent impairment rating. So certainly the carrier could come in and claim that whatever the claimant needed from that point forward wasn't related to the compensable condition. But that's not what happened here. The judge found that the claimant had, the risk condition was compensable. The judge also found in his 2002 order that it was a permanent injury. So all the claimant was doing in this particular case was asking for permanent total disability benefits based on that risk condition already found to be compensable. The way I look at the 120-day rule cases and what you're saying is this.
I'm not saying it, I'm asking
Well, I know, I'm sorry.
Okay.
If the carriers, and there's one case out there, it's not cited in the briefs, but if the carriers from the get-go said, we're accepting the aggravation of the pre-existing condition and that's what we're treating, then fine. Then when the aggravation reaches its MMI level or whatever, then the issue might become, well, is the aggravation still the major contributing cause or is it the pre-existing condition? But when the carrier treats the whole condition, when the judge finds that the whole condition is compensable, then that should be the end of it. Otherwise, we're going to be relitigating major contributing cause all the time. It's contrary to 440.015, which says the statute should be interpreted in a manner to give the claimant benefits in a timely and effective manner and all that sort of stuff. If we retry major contributing cause every time, particularly in a situation like this where major contributing cause was already tried once in 2002, it's going to create a lot of litigation. And from a factual standpoint, there's no indication. They didn't file a petition for modification. There's no indication in this record that there's any change in the claimant's condition. Dr. White was never redeposed after his December 19th, 2001 deposition. That's why everybody refers to it.
Counsel, is it your position that these new attempts by the carrier were attempts to show that the workplace injury was not the major contributing cause of the risk injury?
It's my...
These subsequent attempts by the carrier, attempts to show that the workplace injury was not the major contributing cause of the claimant's risk injury.
That's what they were trying to establish, yes, in both the first hearing and the second hearing.
And because this issue or issues had already been litigated before the JCC, they were barred by the doctrine of res judicata and our collateral estoppel.
Yes. And this court's already said, now granted it was a January 1st, 1994 case, before major contributing cause even came in, if that has any bearing on it. But this court has held, and it explained what are non-recurring issues in that Nelson versus Holtzclaw case. What's a non-recurring issue, such as wage loss, et cetera, that can be retried, non-recurring issues such as permanent impairment or compensability cannot be retried. It's barred by res judicata, whereas recurring issues such as wage loss and that type of thing can be retried because it affects different periods and so on and so forth. We submit this is a non-recurring, non-retriable type issue. On apportionment, the judge properly determined that there is no apportionment in this case. There's no testimony as far as the wrist is concerned. There's no testimony as to how much the pre-existing condition by itself caused the claimant's disability. Dr. White couldn't say. He says, I can't say. And there's two cases I cited in my brief that without testimony as to the percentage of disability, the judge cannot find for apportionment. Now that's as it relates to the wrist. And please note, they haven't challenged the judge's finding that the claimant's PTD based on the wrist. I mean, that's not one of the points on appeal. The second issue that they raised on apportionment concerns the numerous other problems that this claimant clearly had: back, shoulder, neck, bunch of them. But the judge properly determined that that doesn't matter. He's supposed to take into consideration, and there's two cases I've cited that support this, he's supposed to take into consideration what benefits the claimant is entitled to based strictly on the compensable condition. Employer carriers are not entitled to a windfall because a claimant has some subsequent injuries or conditions. The judge found that based strictly on the wrist, the claimant's entitled to permanent total disability. So there's no apportionment. Even if the claimant was permanently totally disabled for some other reason also, it doesn't matter. Claimant's PTD for the wrist, claimant gets the benefits. Now, if they're relying on the apportionment testimony from Jerry Panaccio, she's testifying as to the back injury precludes this, the neck might preclude that. Well, that's not what apportionment's all about. Apportionment deals with apportioning out what part of the compensable injury, or what part of the injury is compensable and what part of the injury is not. And if there's testimony as to that effect, then the claimant would only get 60% of his PTD or whatever it is. But in this case, the judge found there was no evidence upon which to support apportionment on the wrist injury. Now, the judge also did say, just got a little time, the judge also did say in his order that the issue of apportionment was res judicata, and I agree that it is not, but the judge also made specific factual findings that apportionment wouldn't apply. So the res judicata comment by the judge in his 2005 order is really superfluous because there's factual findings that support the fact that there's no apportionment anyway. So we thank you very much.
Thank you.
Your Honors, I'm afraid from that presentation that we may be missing the entire point of our appeal. Major contributing cause was not the benefit tried in 2002. The benefit sought in 2002 was surgery. The evidentiary standard to obtain that benefit is whether or not, at that time, the accident was the major contributing cause of the need for that benefit. And it was. That's not the issue. The issue is whether it's the major contributing cause of the need for the benefits that were tried in 2005, and we weren't allowed to present testimony. I'm going to quote language from this Court's most recent opinion, the Mims case. It says, "A carrier is not precluded from denying a specific claim for benefits on the ground that the injuries resulting from the compensable accident were not the major contributing cause of the claimant's need for such benefits." And it talks about Checkers, where it was the major contributing cause early in the case. But the assertion was that the benefits sought later, the injury was not the major contributing cause of the need for those benefits. Perfectly adopted and approved in Checkers and all these other cases. And the judge wouldn't let us present the evidence. He simply said, well, if it was the major contributing cause of the need for surgery in 2002, then whatever the claimant wants related to that wrist, you're done forever. And that's completely contrary to all these cases. We're not trying to relitigate compensability. We stipulate it was a compensable event. The only question is, does he get permanent total disability, temporary total disability? All of these things much later in the life of the claim. We assert that we should have been permitted to present the evidence, and the judge should have ruled. We ask you to remand the case. Thanks.
Thank you, counsel. Thank you
I
both.
commend counsel on a very well-argued case.